Hello, I'm Frank Hartman with the Hartman Law Firm, and I'm a practicing attorney in Charleston, South Carolina, specializing in auto accidents and personal injury. Today we're going to answer the question, what is a search? And we're going to discuss a Supreme Court precedent called U.S. versus Katz, which dictates what a constitutionally protected search is under the Fourth Amendment. In order to fully explain it, I need to give you a little bit of background on what happened with Katz. Katz was a guy who was using a public phone booth essentially to call his bookie across state lines, which is what made it federal. The feds wiretapped the public phone booth, and they got the incriminating evidence and they brought it to court. Ultimately, Katz got off because the court said essentially both sides were arguing the wrong side. They were arguing the wrong point. What they said, the majority decision said, was that the Fourth Amendment protects people and not places. What really came from this particular case is not so much the fact that Mr. Katz got off, because I think if they were to go back and do it over again, in all likelihood, they would find that he did not have a constitutionally protected right under the Fourth Amendment. And what this is having a protected right about something you're trying to keep private, but you're conducting it in a public venue. What has really come of this case is not so much the majority's opinion, which was to say that the Fourth Amendment protects people and not places, and therefore they didn't really talk about what a reasonable or what a constitutional protected search would be. What really came of this case is the actual concurrence by Justice Harlan, and that has actually superseded the actual case itself and has become the law. A concurrence is where a judge essentially agrees with the majority opinion, but he adds his own opinion towards the end. Justice Harlan he actually addressed the issue of what is a constitutionally protected search when you're in a public place. He enunciated a two-pronged test. The first of which is, did the person exhibit an actual desire or expectation of privacy while they were in public? This is a subjective test. It would be largely factual in nature. The person's out in public. Are they making an effort to do whatever they're doing in such a manner that they're not going to be detected, that they don't want other people to know? They're exhibiting the intent to keep things private. The second prong is that expectation of privacy one that society would consider reasonable? Reasonableness is the general squishy standard that kind of overarches a lot of our civil jurisprudence. And again, it's a factual inquiry, and it would be essentially a jury, 12 people of your peers. Are they going to look at that and think that in the context of whatever it is that you're doing, be it at a baseball game or a phone booth, as the instant case is, wherever you are, would 12 reasonable men agree that you had a reasonable expectation of privacy in that particular venue? And if you did, then it's a constitutionally protected search and you have Fourth Amendment protections. If it's unreasonable, then essentially the Fourth Amendment does not apply, and whatever evidence that they gathered, the judge would allow it in. It would not be kept from the jury. I think a good way to demonstrate this would be to actually take the facts of the Katz case itself. In modern day society in 21st century America, do we think that 12 reasonable men would think Mr. Katz had a reasonable expectation of privacy if he was using a public phone booth? Currently, if it was put in front of a judge now, I think in all likelihood Mr. Katz probably would not have a reasonable expectation of privacy in that venue, because he's using a public phone booth. And when you're out in public, to some extent, you give away your particular rights of privacy under the Fourth Amendment. I think if the Katz opinion were handed down now, the outcome would be largely different. And this is an example of where the Lord giveth and he taketh away. Mr. Katz actually got off as far as the actual factual circumstances, and that evidence was not allowed in against him. However, you, i.e. the American public, and me, we lost because our Fourth Amendment was actually curtailed just a little bit more in this particular instance when you're in a public place and you're looking to keep something private. I'm Frank Hartman with the Hartman Law Firm, and if you have questions about law generally, auto accidents, the Fourth Amendment, whatever you'd like to discuss, I would encourage you to pick up the telephone at 843-300-7600, or feel free to look me up at thehartmanlawfirm.com. And again, thank you for watching.